Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here today to talk about a motion that Steve Greenberg filed on yesterday. I waited to bring this information to you all because I was hoping that the prosecution would have responded to the request and then I could have done this all in one video, but they still haven't posted their response. Judge Ann Dunley has given them until February 4th to respond to the motion. So I don't know if they're going to, do it right away or if they are going to wait until the 4th, but I'm going to go ahead and bring you the information here. But before we get into that, you all know that Rob posted or approved for one of his songs to be released back on January 8th, which was his birthday, and that song is titled Not Supposed to Be. Well, that song has now been placed on both Spotify and on Tidal, and so it's under an artist by the name of Rob. But if you click on the bio for that person, there's an image of a white guy. And whoever these accounts belong to, they are a verified artist. They have like a blue check and everything. And it says in the biography for that person, it says Rob is an artist of Kosovar descent and he means business. So that's all that's there. There's about, I know on the Spotify account, I believe there's about 4 or 5 other songs that are under this account. So I'm not sure what all of this means. If these 2 accounts are approved by him, if his team is behind these accounts, I have no clue. I thought it was a little odd there, but if you want to, go on Spotify and Tidal and play the song, I don't know who is getting the revenue from the songs. Right now, there isn't that many views on it. And you guys know you have to have like hundreds of thousands of views to make any money to begin with. And so it would be interesting to see, down the road who this turns out to be that is behind this account. So I'm not telling somebody don't support the channels, do support the channels. I'm just saying that I have no idea who is behind these accounts, and you can listen at your own risk. The other thing that I wanted to talk about, someone had said something about Sony owning R. Kelly's trademark or the trademark R. Kelly, and that is not true. He actually owns his own trademark. He has 3 trademarks under his name, and one is for goods and services, clothing, t-shirts, pants, vests, tank tops, like any type of clothing that's out there, footwear, headwear, hats, baseball caps, and visors. And then the second trademark is for goods and services. It says entertainment services in the nature of live musical performances. And then the third one is for musical sound recordings, pre-recorded compact discs, audio cassettes, videotapes, and audio-visual discs, all featuring music. And all of these are under his name. One of them is out for, and so one of them is backed by, the care of person. So it has Robert Kelly, an individual in the United States, and then the care of, or the person that you would contact regarding these trademarks. One is a law firm out of Los Angeles, California. And then the other 2 trademarks are Darren McDavid's company. So I don't know if that's a good thing or a bad thing, but if you wanted to get information, you would have to contact Winkler and McDavid. Now, the concern I have is that these these trademarks are all up for renewal, like in the next couple of years. One is up for renewal later this year. Another one is up for renewal. Let's see, this one, the one for the music, I believe is up for renewal this year in like August. And then the one for the entertainment services, it should be up for renewal next year. And then the first one that, was the clothing and all of that, it should be up for renewal in 2025, if I'm reading this correctly, on how these renewals take place. And so hopefully these agencies that are listed as the contact will, stay abreast of this and renew his trademarks, on his behalf in the event that, he is still incarcerated when they come up for renewal. And so that was two things. And then the third thing, which I probably shouldn't even mention, was Drea was on another one of her rants the other night over on her IG. And basically the same song and dance, where she's telling everybody off about, what a wonderful wife she was and how they can't tell her about her story and how she earned the right, to continue the name Kelly. So it was like that same conversation on repeat. So let's go over to the motion that Steve Greenberg filed. Steve filed this motion, talking about he wanted, the anonymous jury, the sequestered jury, to be revisited because he doesn't think that it was fair. And so in the motion, he states on October 8th, 2020, this court granted the government motion to impanel an anonymous and partially sequestered jury. Limited portions of that motion was agreed to by Mr. Kelly and his counsel, but the court went beyond what was needed, and Mr. Kelly now has serious concerns regarding the scope of voir dire, and you guys know that is the jury selection process. So relevant here, pursuant to its order, the court intends to keep the jurors' identities completely anonymous, concealing them from not only the defendant, but also from his counsel. Thus, it appears that social media information, the names, the jurors' employers, and even the jurors' neighborhoods will remain secret. Mr. Kelly asked the court to revisit those portions of its ruling. To be clear, what Mr. Kelly and his counsel are requesting is that the court provide counsel with the jurors' social media, employment, and neighborhood information. This information is essential to any effective and meaningful voir dire. It is hard to imagine that there is a case pending that has not had more pretrial publicity. These allegations were the subject of two multi-part so-called documentaries watched by tens of millions of people. The allegations continue to be the subject of endless online commentaries. Indeed, some of the alleged victims and some of the government's other witnesses have extraordinarily active social media profiles. There might be more material in the public domain via social media than what would be contained within the government's still forthcoming production. Both the defense and prosecution should be allowed to explore whether prospective jurors have commented about the allegations or have social media connections with alleged victims or witnesses. The limitations here place far too much weight on the jurors' self-reflection and raise serious concerns. And then he cites, and that is because prospective jurors may have an interest in concealing their own bias or may be unaware of it. And he's citing a case, Smith versus Phillips. And he says, see also Sampson versus the United States. And then in the notes he has, or the bookmarks, it has Mr. Kelly and his counsel still remain that there is absolutely no reason for the jury to be sequestered at all or for the jury to remain anonymous, except with the respect to the media during the trial. Accordingly, this motion does not waive or change defendant's prior position in opposition to the government's motion, but simply seeks a modification to the ruling this court already entered, in which it rejected defendant's position. And then it picks up and it says, after they talk about the different cases and things that were in cases. So like one of the cases that they're citing, it says, a juror who harbors a bias may not appreciate it and in any event may be reluctant to admit their lack of objectivity. So asking them only whether they had read anything that might influence their opinion does not suffice, for that question in no way elicits what, if anything, they have learned, but lets them decide for themselves the ultimate question, whether what they have learned had prejudiced them. And that was a case, Rhodes, United States versus Tarsanov. So then he picks back up and says, a defendant has Fifth and Sixth Amendment rights to a fair and impartial jury. Admittedly, that does not mean that the defendant has the right to know each and every detail of the jurors' lives. The district court certainly has the authority to impanel an anonymous jury, United States versus Kader. Here, although the defense agrees with this court's decision to impanel one, the defense respects the court's order. Nonetheless, the court has gone too far by concealing certain information, not just from the public and the defendant, but also from counsel. Considering a recent challenge to an anonymous jury, the Second Circuit, after discussing the typical protections taken to ensure fundamental rights are safeguarded, not most importantly, the district court protected the appellant's fundamental rights by ensuring that the jury was not anonymous with respect to any of the parties. While the jurors' identities were kept from the public, the appellants and their counsel and the government too were provided with the names of the prospective jurors during jury selection and were free to investigate any of them for potential bias. United States versus Napalm. And then he goes on to say in footnote 2, this court relied upon Napalm for a different proposition, that the jurors' identity should remain anonymous because of an alleged potential threats, citing the actions of a third party unrelated to Mr. Kelly. The court's reliance on wholesale anonymity is misplaced. The Napalm court relied upon cases where threats to cooperating witnesses had been made by apparently unindicted co-conspirators. In the case at bar, there is no evidence that Mr. Kelly had any involvement in what others had done, i.e., if it happened, it was not a co-conspirator at star 9, and then they're talking about a case from 2019. And it says, this court also wrote in a footnote, I am unpersuaded by the defense claim that it needs not only the prospective jurors' names, but the names of their employers so that counsel can run what amounts to background checks on the prospective jurors. Perhaps the court is correct. Both names and employers are not necessary to enable a background check, which can be done with just the name. The real issue is, however, whether what this court calls a background check needs to be run on the jurors. The defense would like to be able to conduct an internet search running the jurors' names through Google, Twitter, and Facebook to learn what they can. That cannot be done if the jurors' names are concealed. To deny Mr. Kelly and his counsel that opportunity simply ignores the present reality of social media world we live in. Not long ago, there was great upheaval in connection with the Roger Stone case because of information learned during post-trial internet searches, United States versus Stone. Likewise, although she was seated, a juror in the Harvey Weinstein case answered a question truthfully on her questionnaire that she was a novelist, but it was only through doing online research that the defense learned the subject of her book was predatory men. Both instances demonstrate the need for adequate information. Furthermore, it is malpractice for an attorney not to engage in social media research of the type requested in the present case, but while the dangers of inadvertent contact with jurors, violating juror privacy, and risking revelations of an improper basis for preemptory strikes are genuine. These concerns are outweighed by the dangers of not conducting online research. Voir dire becomes voir Google. Ethical concerns of 21st century jury selection. And that is an article that he is citing that was on the American Bar website. To this point, even the slow to change ABA has issued formal opinion 14 through 466, Lawyer Reviewing Jurors' Internet Presence, and that's the title, opining that it is not unethical for a lawyer to review the internet information for a juror so long as the lawyer refrains from communicating either directly or indirectly with the juror. The New York State Bar likewise has an ethical guidance, Guideline 6, which provides for social media research and has issued 2 ethics opinions approving of the process. The reason for that is that much can now be learned about someone through that kind of research, and it is expected that lawyers will do that research ethically and properly. In 2012, the New York State Bar Journal published an extensive article regarding social media searches, including discussing its benefits. Here, counsel is not asking that this information be made publicly available, nor that the information be shared with Mr. Kelly. Instead, counsel requests that all of this information be made available for use by the attorneys only, both the government and the defense. Unless the court can point to something specific, there should be no concern with the attorneys keeping the information confidential. Indeed, to the extent anyone wishes to raise an issue with any social media posting, if the public disclosure is of concern, the line of questioning can be flagged for the court in advance and done securely. The jurors themselves could also be made aware of the potential for the searches in advance. In a similar vein, the identity of an employer and not just the chosen line of work is important for voir dire purposes. 2 people may engage in the same profession but differ greatly in how they view their work and how their profession shapes their views. One only needs to look at the differences in this case. We are all lawyers, but certainly the prosecution has different viewpoints than the defense, not only about this case, but likely across the board in many matters of life. The same would be true of a plaintiff's personal injury lawyer versus an insurance defense lawyer. A police officer working in the heart of Bronx may have a different perspective than an officer working in the Hamptons. Someone working with Fox News likely possesses different views than someone employed by CNN. The examples that the defense could provide are too numerous to list. Each have the same profession but likely vast different views. The examples already provided illustrate the larger point, which is that people's viewpoints, how they view the events of life, and how they would view the evidence in this case are shaped by their everyday experiences. Those experiences include where they work, not just what they do. It is no more and no less important than where they obtain their news, what their hobbies are, and any other areas that the court is permitting inquiry into. It is just a larger piece of the pie. Similarly, although the court may have reservations about providing specific addresses, it should, at a minimum, provide zip code and neighborhood identifying information. Such information does not prejudice or put at risk anyone. More importantly, this information is extremely relevant to the parties' assessment. Mr. Kelly understands the court's concerns about keeping the identities of the jurors concealed from the public, but to not prohibit counsel from knowing other basic, necessary, and crucial information underlying their voir dire assessments is not only unnecessary and without basis, but denies Mr. Kelly the opportunity to conduct full and fair voir dire and violates his constitutional rights. Sincerely, Steve Greenberg. So I guess these folks have lost their minds because in the beginning, it was basically, Greenberg would know who the people were, R. Kelly would know who the people are, but the council would know. But now it seems like they're doing a whole blackout of the defense altogether and just basically giving them the names. And I'm thinking at this point, why even invite them into the jury selection process if they don't know anything about these people? Like, will they even be in the same room with the people at this point to be able to know if they black, white, Indian, Asian, young, old, in between? Like, this is so crazy. And I actually received a jury summons back in December, and I went on Facebook and I posted, I think our guy is named Ken Burke or something. I said, I really need Ken Burke to get my name out of this system because I am so tired of getting called for jury duty. And 2 weeks later, I got a letter telling me my services were not needed. So social media does play a role, and I really do believe. So I don't know if they excused me because I posted that or because one of my mom's good friends was killed by a drunk driver in, I think it was like the end of 2019. And so when I made that post, her daughter commented and said, no, we really need you to be on jury duty. And so evidently the guy who, was responsible for the accident that killed her mom is getting ready to go to court. And so she was thinking that, hey, you might end up on that jury. So I don't know if it was the fact that I made that comment on Facebook or if they read her comment and they figured out that I actually know, the person, that this trial is going to be about. But they quickly sent me a letter and said, you don't even worry about it, sis, okay? And so I agree with Steve Greenberg. Like, this whole thing is just so crazy that they think that they are going to sit a whole jury and nobody knows anything about these people. For all we know, these could be people that they hired, to specifically come in and render a guilty verdict. Like, I hope that this is something that if they turn him down and still say no, that they can file an appeal, to the appeals court and get them to overturn this ruling, because they have already shown, that they're willing to do anything to win this case. And this would just be one more thing. And, when I was, doing the recaps for Power, I was telling you guys, I really think that 50 Cent is shading the Eastern District of New York when he is writing for Power, when they're writing the storylines for Power. And in this last season, that just ended, they had that whole thing about the jury, and where they basically picked the jury that they wanted. So the United States Attorney over the Eastern District of New York in Power actually picked the jury himself, like went to the defense attorney with pictures, like this is who the jury is going to be, and that's who they sat on this jury. They went through this fake voir dire process so they went through this fake voir dire process, pretending like, they were really questioning these people and whatever. And even the judge was like, what the hell going on here? But they already knew who they were going to pick for the jury in order to get the verdict that they want. And I know that that's just a TV show, but the more I watch Power and the stuff that 50 Cent does, the more I think he is really trying to expose the Eastern District of New York. So the next thing that I want to talk about very briefly, and it'll really show us just how fair things really are, because have you guys been following the story about T.I. and Tiny? So one of Tiny's friends has come forward and accused T.I. of, holding a gun to her head or something like that, she said. The lady at question, the former friend of Tiny's, her name is Sabrina Peterson, and she runs a company called Glam University, which I guess is some kind of empowering women or something she has going on. So Hot 97 wrote, Tiny's former friend Sabrina Peterson made a serious accusation against T.I. In an Instagram post, Sabrina claims that T.I. allegedly put a gun to her head while children were in the room. And so this was the post that she made on Instagram, and the Instagram account is The Glam University. She says, the sad part about being a woman and being a black woman is this: the public praises our predators. At Troubleman31, which is T.I.'s handle, you put a gun to my head in front of children and I never called the police on you. But for years you have painted me as the villain. As black women, it's hard to heal from rape, violence, or anything because you are painted as the problem or reason this has happened to you. Let's normalize the allowing black women to heal. It's so hard being the victim of rape and being painted as the reason it happened. Let's talk. At Keisha Bottoms, who is the mayor of Atlanta. You can't have a person that has victimized women speaking for us. Let's have a real talk. And so I don't know why she bringing Keisha Bottoms into the situation. And I also don't understand why this has to be a black woman thing. Like, why can't it just be a woman thing? Like, this happened to me, blah, blah, blah. Like, why we all got to put the race card into it as, you know, I don't know, like that gives it more validation or whatever. So on the Wendy show today, I believe it was today or yesterday, she responded, and I didn't really like Wendy's response because she basically was telling this lady to forget about it, get over it, move on. It happened years ago. Like, you're clout chasing, you're going to ruin your brand. Whatever this Glam University is, you are going to ruin that brand if you keep up with this talking. So let it go, zip it up, you know, put it in the past. And I'm thinking, okay, y'all got to make up your mind. If you want women to tell their stories, then say tell their stories, but you can't pick and choose based on who the woman is accusing, whether or not you're going to believe them or support them or whatever. So I thought Wendy was way out of line when she said that. And then, of course, Tiny has come out in defense of her husband, you know, saying that this woman is lying, that this never happened, you know, that, you know, she's making this up or whatever. And she wrote, hold up. So you want your abuser to train your sons? He was just uncle 2 years ago. Now, when did you say my husband assaulted you? Did you change your mind or change it back? What with you to what? I guess she's saying what's with you today, Pooh. I'm confused, she wrote. Stop harassing my family, you strange. Everybody know you've been special. Face slicing seminar lady, please get help, but leave us alone. So although Tiny responded to her, T.I. hasn't said anything, and the Keisha Bottoms lady hasn't said anything. And, you know, it's really sad that this is playing out this way, because now she's claiming that women are reaching out to her with their stories about what, you know, transpired between them and T.I. and saying that this is nothing new, that he is basically a predator. And the things that they are accusing T.I. of doing involving drugs, involving doing things to people when they were not able to consent, you know, involving, you know, cursing people out, just being very disrespectful to them, getting what he wanted from them, and then just tossing them to the side, having security drag them out of the room. And so people are saying, hold up, you know, victims of T.I. and Tiny are speaking out. Almost all their stories are identical, and they involve drugs, coercion, and the R word. And so it says there are a lot more victims and they've shared their stories. Check out at Glam University Stories on Instagram to read more. And that's an account, Jiggles, at Love Jiggles on Twitter. And so I'm not sure if this is an account for the Sabrina Peterson lady, or if this is somebody else who just picked the story up and is sharing the information. So what I want to know from you guys is, does T.I. deserve the same treatment that Mr. Kelly has received? Would Dream Hampton be doing a docu-series on Lifetime about this? Or is it because everybody loves T.I., that this is just going to get swept under the rug in a couple of days and we are not going to hear anything else about it? Because there is definitely a double standard, when it comes to Mr. Kelly. And when I tell you the stuff that these people were writing, claiming that T.I. had done to them, none of that stuff was Mr. Kelly accused of. Okay, like he was not accused of doing any of this stuff they got on here about Mr. T.I. So if you want to read the post that this Love Jiggles posted, go to her handle on Twitter, and people are chiming in. They're leaving their comments. Some of them say that this woman is just jealous and she's being petty, and other people are saying that they believe every word of it. So that's it for me. Just want to throw that out there to show this double standard, how people were, immediately ready to pounce on R. Kelly and believe everything that was said about him. But then they kind of want to wait and see and give the benefit of the doubt, about T.I. And then I was really surprised about Wendy and her stance, considering when she did kind of sort of try to defend her friend Rob, on her show. She almost lost her show, but then she openly, defended T.I. in this case, where this woman says that, he pulled a gun on her. So let me know what you think. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.